the first wife of the late AmaZulu king, that's Goodwill Zwelithini, is seeking to have the Pietermaritzburg High Court declare his other 5 marriages, invalid. Queen Sibongile Dlamini-Zulu initially argued that she was entitled to half of King Zwelithini's estate because they married in community of property. The legal team now intends to amend its initial application by having other customary marriages declared invalid. Newzroom Africa's senior politics reporter Ziyanda Ngcobo was in court for us. She filed this report.
Before the nub of Tuesday's court proceedings could get underway, the case was diverted towards hearing whether or not Judge Mjabuliseni Madondo should recuse himself from overseeing the matter. The judge once presided over one of the weddings of King Goodwill Zwelithini Zulu. This brought the issue of the validity of the late king's other 5 customary marriages into sharp focus. Lawyers representing the king's first wife, Queen Sibongile Dlamini-Zulu, and her daughters, Princesses Ntombi Zosuthu and Ziyanda Ngcobo, argued that this had to be declared before going further.
Our contention is never in South African law has that ever been the case. One could never marry, if one got married by civil law under the Marriages Act, it precluded any subsequent polygamous marriage with another person.
But Judge Madondo dismissed this attempt, saying Queen Sibongile had not formally asked the court to look into whether the other 5 customary marriages were entered into legally, and she, in fact, also recognizes them.
The applicant queen herself has clearly conceded in her affidavit that these marriages are recognized now by the Recognition of Marriages Act. She does not want the friction or ructions in the royal family to such an extent that she does not want these other queens to be evicted from the palaces they presently occupy. Even their children or the children of the king should be treated equally, whether born of a civil or customary union or marriage. So that clearly shows that the omission of that relief was not a mistake, but it was deliberate.
After losing their attempts to investigate whether the judge should recuse himself, the applicant's lawyers sought to amend their initial application to have the court officially declare the other marriages invalid.
My instructions, my lord, are to seek an amendment. I need to formulate the amendment. It will take about just a couple of minutes. It basically will be to insert a specific challenge to the validity of the king's marriages.
Lawyers representing King Zwelithini have argued that the applicants had ample time from July last year to amend their application, and this last-ditch attempt should not be entertained.
Is that if this application for amendment had been properly brought in terms of the rules, Rule 28, we would have said to your my lord in an opposing affidavit that the delay, the application for the amendment will cause a delay into the whole dispute and the resolution of the matter, because it will force an adjournment. If on our basis we have to deal with it properly, the matter will have to be adjourned. And there are many reasons why it is not in the interest of justice, not even in the public interest, that a case of this nature should be further delayed. In our application for the special allocation on a preferential basis, we set out the reasons why the uncertainty about the truth was prejudicing not only the respondents but also the entire Zulu nation.
Wednesday's proceedings will deal with whether or not a new application to have the court officially declare the late King's other 5 marriages invalid will be entertained at this late stage. This clarity will pave the way for the debates on who is entitled to the estate of the AmaZulu king and whether Zwelithini's will was forged. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Pietermaritzburg.